Hey everybody, what's up? I know I've been a little busy because my daughter's graduation was last Saturday, and then had to go back to work Sunday, and then Memorial Day I had to work, and then the day after that to get paid for the holiday. Y'all don't even know, but rest assured, I will never leave you guys, never leave. So I'd like to thank everyone for coming to Sandra's stenography and shorthand dictation, and haven't had enough people hitting that like button, so you can go ahead and do that now. And you can share, like, leave me a comment at the bottom of the video, hit the bell for notifications so you can join me live, all that good stuff, so I appreciate that so much if you guys could do that for me. Even the guys that don't watch this on YouTube, you can still come over here and hit the like button. Is that too much to ask? After all I do for you guys? Come on. So anyway, let's get that out of the way. I got that out of the way. So I'm coming back with some more you ever be talking and your mind just go blank? So I'm back with, as you can see from the title, Jeffrey Macdonald. We still on Jeffrey Macdonald. And we still on, I'm still doing the dictation from the Jeffrey Macdonald case. This is part 4. And the defense is talking. So we're going to leave off where the defense, we're going to start off where we left off with the defense speaking. And on that last video, right there at the end, I said we are to be concerned about advocating the cause of Jeffrey Macdonald, who pleads not guilty. And I said, please guilty. So forgive me for that. But who is this talking? Lord, if I try to find the man's name, I'm gonna lose my place. So we're not even gonna go there. I've already done part 1, part 2, and part 3. You can find those on my channel under playlist. Hit playlist, and then look for the Jeffrey Macdonald case, and you'll see the other 3 videos that I have already done on this. And this is gonna get juicy, y'all. So I hope y'all hang in there with me, because I read this every chance I get, every time I have a chance to read, and so I can read ahead, so I know what's coming up. This is about to get juicy once we get all of this opening statements out of the way. So this is the defense. This is the opening statement, and we're gonna go ahead and get started. Ready, guys? Ready to write? Ready to do your voice writing? Ready to, this video is private. I have not sent out any notifications that I'm doing this video because I just got off from work and I'm tired. So I'm just gonna do this one on a private. And I think I'm gonna do a couple of videos tonight so I can release them during the rest of the week. So if you see me with the same shirt on, it's not because I haven't changed clothes. It's because I've probably done several videos tonight, and I'm just going to release them as the week goes on. So I'm not expecting anyone in the chat. I'm just going to go ahead and get started on this. Ready? Give me one moment. All right, I'm back. Sorry about that, but just have to whip my throat before I get started with this. All right. Ready? Go ahead and get comfortable here. All right, let's go ahead and write, people. Those are the functions of the judge, the government, and the defense. The function of the jury, of course, is to presume Jeffrey Macdonald to be innocent. I don't know that you could say that you are required at this point to be in his corner, but I have thought of it that way, to be on his side. Maybe that is too much. Maybe that is not what the system says, but it does say that in each of your minds at this very moment, right now, in each of your minds, you must be presuming that he is innocent of all charges, that he did not do it. You must be presuming that. I think our founding fathers really were serious about that. I think they really meant it when they said that the jury presumes the defendant to be not guilty. And we ask you at the beginning of this trial to do that. When I was a boy growing up in Albemarle, North Carolina, we used to go to the movies on Saturday and stay all day. And there was always a Western movie on. And we always watched the previews because we wanted to see what we would be watching the next Saturday. We enjoyed these previews, and it helped us a lot. It helped us all week to anticipate what we were going to see the next day. That is the purpose of the opening statement. It is not necessarily something to enjoy. Maybe in some cases you'll enjoy, but in this one, there could not be anything to enjoy. But it is a preview. It tells you what is going to happen and to serve a very useful purpose. Mr. Blackburn used a good term when he said, use a broad brush treatment. We will come back in the course of the trial and use a fine brush. We will paint in the detail for you. We will add color for you. We hope at the conclusion of the trial, it will be a clear picture for you so you can understand the evidence and make your decision. Then, let me make an opening statement on behalf of Jeffrey Macdonald. I will paint a broad brush. This is a case about a family. It is a story of how a family came to be. It is a story of an unbelievable and unspeakable tragedy. It is a story of good people, a mother, a father, and 2 children, 5 and 2. The mother was 26 and the father was 26. It is a story of happy people. Ladies and gentlemen of the jury, the defense will show you the story of a family with life motives, no death motives, life motives, alive, new birth coming. The defense will show you all life motives, every reason to be happy. The defense will show you every reason to be living. We will go back to the beginning. We will show you a young boy growing up who is just like hundreds of young boys you have known. Just like them, Jeffrey Macdonald, athlete, good student, leader, always excelling, always doing well, always motivated to do his best. Not a lot of money, going to school at Princeton on a scholarship, doing well, going to medical school at Northwestern, doing well. We will bring into the picture then Colette, Colettee, a fine woman, a fine person. We will show you how he got a choice residency because of his work at Northwestern. We will show you how he volunteered for the military, how he volunteered for the Green Beret, how he was proud. We will bring to their home the two children, Kim and Kristen. We will bring them to Fayetteville, to Fort Bragg. We will produce testimony that Dr. Macdonald, he was a doctor then, was working 2 extra jobs, moonlighting, to make enough money so that his family could live, not die. We will show you how they had bought a pony for the children. We will show you how they had bought a few other things for the home, because they are now getting on their feet, ready to live, not die. We will show you how they eagerly anticipated the arrival of the new little one. Colette was 5 months pregnant. And then we will show you how it ended, how the whole thing in a matter of minutes ended. Ashes. Yes, we will show you how Colette went out, how she went out for a class, how Jeff, as we will call him in this trial, stayed home with the children. We will show you how he played with the children just like you have done, how presently the time came to put them to bed. And he did. We will show you how Colette returned home, how they were happy together, how there was peace and joy. We will show you at that moment that there was nothing insane about Dr. Macdonald, that he was not on drugs, that he was not intoxicated, and she wasn't either. We will show you then how Dr. Macdonald, or Jeff, happened to sleep on the couch. And we contend that the evidence will show that the little one, Chris, had a habit of getting up from her bed in the night and coming to sleep with mommy and daddy. That has happened in your home. And how every now and then she would wet the bed. That has happened in everybody's home. We will produce evidence which will show you that after the little one went to sleep, she did get up and got in bed with her mother while Jeff was up watching television, and reading. And when he got ready to go to bed, finding a little girl in his place, on his warm side of the bed, and a puddle there. He simply picked the child up, returned the child to her bed, and faced these options: sleep on a puddle of water, wake up my wife, and change the sheet, or just leave it the way the Lord flung it and go to sleep on the couch. We will show you he selected the last option, and we will bring you through his words from the witness stand, face to face with the people who did this. You will see them through his words, and you will hear the words of his child, the words he can never forget, obviously. We will show you that he heard and will hear for the rest of his life, Daddy, Daddy, Daddy. And then, as if in slow motion, things started to happen. And they have happened and happened and happened for all of the years since 1970. We will show you a man who has tried to forget somehow. We will show you a man and will produce evidence that he is an outstanding physician now, right now, that he is recognized in his field all across the country. Emergency room medicine. We will produce evidence showing that he has published a book, that he is the best. And yet, we will show you how he has been lonely. Ladies and gentlemen, I heard a poem one time. I heard it more than once, really. And it says something like this: I slept and dreamed that life is beautiful. I woke and learned that life is duty. We thank you for accepting the duty and responsibility in this case. We will do our best to perform our duty. We will produce all of the evidence that we can find, whatever it is. And let me say this. For example, the government says through Mr. Blackburn that they did a lot of interviewing. We will produce a neighbor, a man who lived across the street from these people, who was never interviewed. And ladies and gentlemen, he will say to you that on the night this occurred, late at night after midnight, he heard voices. And we will present evidence that will show to you that he saw three people, one of which was a woman with long blonde hair carrying candles, walking toward the Macdonald home. We will present other evidence for you. We hope that you will take seriously all the things the judge said to you, all the questions that he asked you, all of the great principles that apply in this case. We hope you will apply them all. We trust you. We trust now that you are presuming the defendant to be innocent, and we are ready now for our days in court. Thank you very much. Mr. Blackburn. Your Honor, may counsel approach the bench? The court. Yes. Bench conference. Mr. Blackburn. We didn't object at the point on the reasonable hypothesis because we did not want to interrupt the circumstantial. We would like a clarifying rule on that or some instruction to the jury. The court. Well, of course, Wade misstated the law. I am sure it was not intentionally. It may be the law in North Carolina. It is not the law in the Fourth Circuit. Mr. Blackburn, we just did not want to interrupt him. Mr. Smith, at any time, Your Honor wants to correct it, I have no objection to it. Mr. Blackburn, we were concerned about the every other hypothesis. Mr. Murtagh, Mr. Smith in his opening statement said that we will prove that there was nothing insane about Jeff, that he was not under the influence of drugs or alcohol. And I think it is not an issue of insanity or sanity. He is presumed sane, and the government does not have to show, other than the premeditation or malice aforethought, the court. I didn't read his statement to the jury as requiring any proof one way or the other. Mr. Smith, no, indeed. Mr. Murtagh, but the word insanity is before the jury now, Judge, and also the motion on Sadoff is still before the court. We think it requires some type the court. Do you have any motion to make, and what is it, Mr. Blackburn? We would move, first of all, Your Honor, that clarifying instructions be given on the circumstantial evidence at this time. Mr. Smith, I would hope that Your Honor would do that when you instruct the jury. Mr. Murtagh, Your Honor, we would also move that the court rule on the motion in limine on mentioning insanity. It has already happened in the opening statement, and I fear it is going to permeate the trial. Mr. Smith, it is not going to permeate the trial, the court. I understand his position to be that he will show the man is sane, and there is no question of his sanity. Mr. Murtagh, yes, Your Honor, but that puts the burden on the government to show that someone would have to be insane in order to commit this type of crime. That is not our burden. The court, I don't follow that. Mr. Blackburn, we would prefer an instruction now rather than later, since the jury occurred now on the circumstantial evidence. The court, well, had you objected timely, I would have done it then. I will now handle it in a different fashion. Bench conference terminated. The court. Members of the jury, an objection has been interposed by the government to a particular statement or contention of the law as to what the law was concerning or the degree of proof. I simply say at this time that while counsel are at liberty to argue in good faith what they contend the law is, that it will be the duty of the jury to take the law from the court. And to the extent, if any, which you find the court statement of the law to be at variance with what any lawyer on either side of the case has said the law in his opinion was, then you will be bound to take the law from the court. The matters which were the subject of the objection will be covered in the final instructions of the court to the jury. At that time, you will be given the principle of law on the basis of which you will be governed and make your decision in the case. At this time, before beginning the evidence in the case, we will take our morning recess, members of the jury. As I have stated to you individually as you were selected, and now I say to you collectively, while we are in recess, at this or any other recess of the court, you are not permitted to discuss the case among yourselves or with others, or to allow, certainly, anything to be brought to your attention concerning the case. And, of course, rigidly to be enforced will be the instructions against reading, looking at, or listening to anything about the case which may appear in any of the news media. Finally, you must at all times keep a fair and open mind about the case. As I perhaps said to you, I frequently do, and you will hear it again. In the very nature of things, both sides cannot talk at once. Consequently, it is unfair to draw conclusions on the basis of what one side is presently saying or presenting without giving equal time, so to speak, and an equal opportunity to the other side to reach conclusions and to argue their intentions. During the course of the trial, I will not repeat all instructions verbatim, but just may from time to time say, remember the instructions of the court. You will know to what I am referring. And of course, they will be in effect at all times during the course of the trial. I will let you go to the jury room. I don't know whether anybody has made any coffee for you this morning or not, but you will find the necessary equipment and a starter bag of coffee for you. You will also find a little refrigerator in which those of you who care to bring soft drinks or other items that need to be kept cold, you may keep those in there. We will be reconvening at 11:25 for purposes of proceeding with the evidence in the case. For your further information as to our schedule, we normally recess at 1 o'clock for lunch and reconvene at 2:30. In the afternoon, we take a somewhat shorter recess than the one we take in mid-morning, such as the one we are about to enter. This will be our normal schedule, except that later in the day, I will give you a somewhat altered schedule, which we might follow on Fridays, or a Friday if you see fit to adopt it. This would mean a little earlier convening in the morning and a little earlier recess on Friday afternoon. Take a recess until 11:25, please. The proceeding was recessed at 11:02 a.m. to reconvene at 11:25 a.m. this same day. All right, I kind of tried to read through that because I didn't want to go too slow, because that's not a challenge for anyone. Or let me say that's not a challenge for anyone, but I did want to read this a little faster, so for my people that can write up faster. So there you have it, people. Yes, we have completed the opening statement from the prosecution. We have completed the opening statement from the defense, and then we have had a little sidebar, and then we have come back with the court with some reiterating some jury instructions, and then we are at a recess. That's where we'll end this tonight. Let me know if this was good for you. If I went too fast, you can leave me comments down at the bottom of the video, as I said earlier. You can like this video. Yes, you can. You can do it. You can do it. You can do it. I believe in you. And I'll have some more good stuff coming to you the rest of this week. I'd like to thank everyone for joining me at Sandra's Stenography and Shorthand Dictation. And as always, I'd like to wish you happy writing. Be blessed. Be well. Until I see you next time. Okay? Thank you all. We will convene as well. We will recess as well. Sometimes I get off of work, I'll be like, anyway. Thank you everyone. Thank you all for coming. I appreciate it. Have a great night, and I'll see you at the next video. Bye.